Hi everyone, today we move on to the last key knowledge point for Area of Study 2 Managing Employees. We look at dispute resolution and this rounds out Area of Study 2 for us. So in the latest study design, this key knowledge point has been made pretty straightforward. So key knowledge point 10, we're looking at an overview of the dispute resolution process, including grievance procedures, mediation and arbitration. So if you look at the keywords there, you'd need to revise dispute resolution process, work out what it is, know an outline of grievance procedures and know an outline of mediation and arbitration procedures to be able to successfully master this key knowledge point. Back in the previous study design, there was a lot more to this grievance procedures topic. So although this is not in the study design, it probably helps build up some background understanding of the grievance procedure. So I'm just going to quickly go through them. I've written on the slides that don't count that it's not actually in the study design, but it will help with your understanding. So looking at conflict in employee relations, conflict in the workplace refers to a dispute between the employer and employees. It used to be known as industrial action or industrial disputes. And what happens as a result of the conflict is there's either withdrawal from work by a group of employees, meaning they strike, or there's the refusal by an employer to permit some or all of its workforce to actually enter the workplace, which is known as a lockout. In cases of conflict, there can be other actions taken as well. So you could have a situation where there are picket lines or blockades put in place to protest outside a workplace. There could be work bans, refusing to work overtime, etc. There could be absenteeism or sabotage, so the classic sickie or mental health day, as covert actions or forms of industrial action to stop work within a workplace. One area that's interesting and was covered a fair bit in the past was protected industrial action. So what this is, when there is conflict between employees and employers, and when there is a new enterprise agreement being negotiated at the workplace, striking is a legitimate tactic when you're in the negotiation phase. But it needs to be protected, it has to be approved by the Fair Work Commission, which means it needs to fall during the renegotiation period of a new enterprise bargaining agreement. You'll probably remember in the news over the last couple of months, there's been Yarra Trams have been talking about taking strike action, and they did take strike action a couple of times. That was protected because they were permitted to do it because they'd given sufficient notice to do it, and it was happening as part of the negotiation for a new enterprise or new workplace agreement. So the Fair Work Commission can still end the protected action if it threatens the wider economy or the interests of other businesses. Parties are then forced to conciliation and arbitration. This also happened with Yarra Trams, who were looking at a strike, even though it was protected, but it was going to happen during the Grand Prix. So there was the government and a number of other parties who were saying that it wouldn't be fair for the economy and the economy would lose a lot of money. The Fair Work Commission then stepped in and said, no, you can't strike at that particular time, and forced the parties back to the negotiation table to try and finalise the new workplace agreement. So conversely to the protected, there is unprotected industrial action as well. So if industrial action takes place before the expiry of a current enterprise agreement, or industrial action is taken without the appropriate notice to employers, the union or the union on behalf of the employees can be subject to legal action by employers against the employees and the unions through the Fair Work Division of the Federal Court. So it can be a pretty major step if the unions don't get their strike action timing correct. So in relation to conflict and dispute in employee relations, we'll just quickly look at the causes of disputes. You just need to make sure you understand that disputes just don't happen just when employees and employers are negotiating new workplace agreements or awards. They happen throughout the year, or throughout the life of the employment cycle. So you just need to be aware of that, because there are different ways that the actions can be handled. So if we've got here the disputes arising during the negotiation of awards and collective enterprise agreements, that's the first one. That's a cause of dispute. Disputes normally over remuneration, employment condition and other agreement related matters, example, job security. So they're the normal things that are factored into a workplace agreement. At the end of each workplace agreement, they expire after a period of time and they're renegotiated. It's normally around the remuneration and employment conditions that it's a sticking point for employers and employees to come to agreement over. So that's a significant cause of disputes within the workplace. The other cause of disputes, which happens the majority of time because workplace agreement negotiations don't happen very often, so disputes arising outside of the negotiation of awards and collective enterprise agreements. It includes health and safety, retrenchments, downsizing, discrimination, union issues, green bans, so working on anything harmful. There may have been discrimination, sexual discrimination, or something like that in the workplace. Any of those are issues within a workplace that can cause disputes, which then need to be resolved. So, why do we need to settle these disputes as quickly and as efficiently as possible? Because they're expensive, obviously. They take up a lot of time consuming, they're costly, they can destroy the employee morale and motivation, and they can damage long-term employee-employer relationships. So it's important that disputes are handled efficiently. So the first way to resolve a dispute is by negotiation, the most simple and the least formal. So it's just open discussions between employees and employers or the representatives. Requires a consultative or participative style from the employer or the human resource manager. They also need to possess interpersonal skills, communication skills, and negotiation skills if they're going to resolve disputes by negotiation without the dispute being upscaled. If negotiating is not successful, then we need to move further up the chain. So we then move to a grievance procedure, so dispute resolution process. So this is a formalised set of steps which upscale a grievance until the matter is resolved. And here we have an example of dispute resolution, the grievance procedure. So the resolution process, we can see here that it's upscaled. That's the main thing when you're looking at a dispute resolution process. There may be different steps, but this pretty much is the formal way of handling grievance procedures and moving towards dispute resolution. So number one, the employee and or representative, they say shop steward here, so which is the union representative. They present a complaint to the manager, which could be the human resources manager. At step two, the employee and or the representative present complaint to the employer. They do that if the human resource manager or the direct manager involved was unsuccessful in handling or resolving the complaint, so it moves to step two. If step two is unsuccessful, you move to step three. The matter is discussed with the human resource manager as a mediator between the parties. So that's the next step. Step four, matter is referred to the Fair Work Commission if that previous step was unsuccessful for dispute resolution. And step five, if the matter is that's being referred to the Fair Work Commission for dispute resolution isn't successful under mediation, the matter is then referred for arbitration, where both sides of a case are argued, and the judge then makes a decision as to which side is awarded the victory in the case. So in the grievance procedure, I touched on the Fair Work Commission and their involvement in the resolution of conflict. So more formally, they're the independent workplace tribunal, the Fair Work Commission. So one of the things they do in addition to approving workplace agreements and setting awards, etc., they can act as a mediator and arbitrator in workplace disputes. So what they do is in the case of mediation, so the independent third party they can be in mediation. So as the mediator, the independent third party helps the disputing parties talk about the issues and arrive at their own agreement resolutions. So they're there to help, but not give any advice. They're just purely there to support the parties, and who must then come to their own, arrive at their own agreement or resolution. So that's what mediation is. If you hear the term conciliation, conciliation is very similar to mediation. What happens is you've got the Fair Work Commission, the Independent Workplace Tribunal again, someone that, or someone they've appointed, similar process, but the mediator makes suggestions as to how to resolve the problem. So rather than just supporting the parties in mediation, in conciliation, they make suggestions as to how to resolve the problem. So that's the difference between mediation and conciliation. Conciliation isn't actually in the study design anymore, mediation is. So just make sure that you know that mediation definition there, how it works, and just be aware where conciliation sits in the actual process. And finally, for the last part in the study design for this, for Area Study 2 in Unit 3, we look at arbitration. Again, this is the Fair Work Commission, and what they're doing is in arbitration, it's a method of industrial dispute resolution when parties can't agree. So they may have been through mediation, even conciliation, nothing has worked. They end up at arbitration. So the Fair Work Commission is the independent third party, hears both sides of the argument, then makes a legally binding order. So their role, they function like a court. So that's arbitration. That's the final step in the process. Whatever decision the Fair Work Commission come up with, it's binding on both parties. So that's the final step in the process once you agree to go to arbitration. The other thing that can also be taken is common law action for grievances and disputes. So if there was a legal action as a result of unprotected industrial action, so striking, that would go through and be action taken under common law. If there was breach of contract, so individual work contracts or work agreements rather than collective bargaining agreements, if there was a breach of that contract, it would be an action under common law. So it'll be a common law action in the court through the Fair Work Commission. So I hope that outlines everything to date. And finally, here's the work for today. So if you read through sections 412, 413 and 414 of the text, you'll see also in the text that there is a section there, I think it's 412, which is again background reading, which is not actually included in the study design, but again it helps to read through it and see, read a little bit more on protected and unprotected actions and striking, etc. But if we can then go to sections 413 on page 195, do questions 1 to 6, 414.1 on page 197, do questions 1 to 5, and 415, page 201, do questions 1 to 4. So yeah, that's it for now. Over the weekend, I'll let you know what the process is with some more revision work leading up to a practice sack of sorts later on in the week. So that's all for now. Bye for now.